By the previous video, we have completed discussions up to Article 118, which related to passing of bills, including budgets, in the legislatures. So the next important article is 122. Today, let us discuss Article 122. It says that the validity of any proceedings in the Parliament shall not be called in question in any court of law on the ground of any alleged irregularity. Similar provisions are there under Article 212 relating to state legislatures. So whatever we discuss here under Article 122, it squarely applies to legislative proceedings of the states as well. It states that the proceedings of the legislatures shall not be called in question in any court of law on the ground of any alleged irregularity. When we said even if there is irregularity, the judiciary is not supposed to interfere, it means that under no circumstances the judiciary should interfere with legislative proceedings. The same way, Article 122 Clause 2 says that no officer or member of parliament in whom powers are vested by or under this constitution for regulating procedures or the conduct of business or for maintaining order in Parliament shall be subject to the jurisdiction of any court of law in respect of the exercise by him of those powers. So the judiciary is not supposed to interfere with the legislative proceedings and even functioning of the in charges of legislatures, namely the speakers and chairmen. The similar provisions are there under Article 212 relating to state legislatures. Please observe under Article 361, the executive exempt from judicial proceedings. No civil or criminal cases can be brought against them, and they cannot be summoned to courts, and they cannot be arrested. So the legislative proceedings are safeguarded, are excluded from the purview of the judiciary, and even the executive are excluded from the purview of the judiciary. Whereas Article 72 gives powers to the President and Article 161 gives powers to the governors of states to waive, reduce or commute punishments awarded by the courts, including death penalty. That means courts do not have jurisdiction over the legislatures and the executive, but the executive can override the decisions of the judiciary. We know the judiciary is appointed by the executive. Under Article 124 Clause 2, the Supreme Court judges are appointed by the President of India. Unfortunately, the system was deviated by the Honorable Supreme Court from 1999 by appointing a collegium to look after appointment, transfer, etc. judicial working. What we understand is that the President of India, despite being endowed with all the powers under the Constitution, and despite being provided all the safeguards under the Constitution, is not exercising such powers, is not using such safeguards. Instead, he confined himself voluntarily to the Rashtrapati Bhavan or the Raj Bhavan, and he is allowing his nominated ministers to rule over the country. Sometimes they are doing it even against the executive. They are treating him as his secretary. At least secretary will have some powers, but the president does not have the powers even of a even of an appointed secretary. He is bound by he is a bonded labor in a sense. He has to follow the advices of the Council of Ministers in terms of the 42nd Amendment of 1976. However, he has to assent to bills which are sent to him under Article 111. He can return them for once. If the same bill is represented to him again with or without modifications, he is bound to assent to it. We don't find fault with that process because separation of powers is the important aspect of democracy. Legislature should have exclusive power to make law. Executive should have exclusive power to rule the country and assent to bills. And the judiciary should have exclusive power to deliver justice, to interpret the law. Of course, there will always be exemptions to a rule. We have discussed previously whether a president and governor are bound to assent to all bills sent to him by the legislatures. We have discussed at length. The president and the governors, being the custodians of the constitution and having devoted their lives to the service and well-being of the citizens of India in terms of Article 60 and 159, they have some extraordinary powers to withhold bills. Withholding of bills, of course, is not any exclusive power. It is, after all, the stand of their political party, and the bills passed by the legislatures is supposed to be the stand of that political party, and withholding it by the president and the governors is supposed to be the stand of their political parties. Apart from that, President of India has powers under Article 364 to maintain major seaports and airports. President issues instructions to the states. They are bound to follow such instructions. If they do not follow such instructions, it is deemed that the state cannot be run in accordance with the provisions of the Constitution under Article 365 and would lead to dissolution of the House and the government. Such is the power of President of India and the governors. But unfortunately, having everything, he is just keeping quiet while the legislatures are taking away his powers through 42nd and 43 amendments. And he is also keeping quiet while the judiciary is taking away his powers by striking down the bills passed by him and the laws assented to by him. The President of India has to wake up. Epiphany has to devolve on him. He has to realize that he is Supreme Commander of Armed Forces, he is executive power of the Union. Nobody can remove from his office as long as he did not violate the Constitution. Impeachment is invalid unless he violated the Constitution. Having so many powers, he doesn't have to care for anybody, he doesn't have to fear anybody. He has to rule this country in accordance with the Constitution. For example, we can see the 52nd Amendment of 1985, which is termed as anti-defection law. Under anti-defection law, if anybody defects from one party to the other, his membership is cancelled. Supposing one-third of a political party defects from one party to the other, they do not attract disqualification. This is a dangerous provision. This is, instead of anti-defection law, this has become a wholesale defection encouragement law. And again, under that law, the disqualification power was given to the Speaker of that House. In fact, it is the power of the President and Governors under Article 103 and 192 to decide on the disqualification of members. And again, through 42nd Amendment, it was added that he shall take such decision according to the advice of the Election Commission. While it was said in 103 and 192, the decision of the President and Governor shall be final. Whereas through 42nd Amendment, it is added that, however, he shall act based on the advice of the Election Council. That means whatever he is taking is not a decision and it is not final. He is only following the advice or instructions. I don't say they are advices. When following such advices becomes imminent, then they are no more advices. They are commands. They are instructions. So the powers of the President and Governors are taken away under this anti-defection law also. It is unfortunate that the highest elected executive in India, the most powerful man in the country in accordance with the Constitution, has remained a silent spectator to the misrule of the ministers and sometimes even against him. While his powers are being taken away by the legislatures, by the ministers and by the judiciary, he is non-reactive. Let us hope epiphany devolve on the President of India on a fine moment and the country will be run in accordance with the Constitution. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. My endeavor shall be to bring to your notice all the conflicting constitutional provisions and explain you how they were misused, misapplied and misinterpreted and misused, with fond hope that our joint effort would bring a social, political, economic change in India.